We're live.
Good afternoon. This is the Senate Education Committee on the afternoon of April 30th. Apologize to everybody for starting half an hour late. It's over in and I got stuck in the meeting. Make it feel even longer. But we're starting off today, Rick Sigal, Legislative Council, looking at a new draft of H650, the ECK bill. So just take 1 second and
Feel like iteration.
yeah, it should start now that we're starting at technical. Okay, so we have a new draft
We do.
and off we go.
Good afternoon. Rick Sable with the Office of Legislative Counsel. I'll share my screen so we can all look at the same bill that I'm walking through, or amendment. So we have draft 1.2 of H650. This would be a strike all committee amendment to H650 as it came from the House. Maybe a little refresher, Mr. Chair, what the House bill was. Would that be helpful? Or
Yeah,
and it's not these are not. We're not rewriting 650. I'll put it in the strike all. I think it's easier for this bill for it to be a strike. I'll explain why. So 650 as it came from the House would require ed tech providers to register with the state. And no enforcement, just register so we know you're doing business here. The second section of the bill required AOE to study on should we certify these products and how should that be done. So AOE would be tasked with a study, bringing stakeholders. How should we certify? Should we, number one, certify these products for use? And if we do, how should that look? And should that be a requirement for ed tech to be used in the classroom? That was as passed by the House. So what you're looking at here has changes. Notes change to page 1. So I'll take to page 2. There's still this registration requirement. A couple of changes to definitions I want to go over. The definition of educational technology product has been adjusted a little bit. So the previous definition, I have the word any highlighted because right after any was the phrase student facing. So the definition would have been limited to software, websites, that are student facing, whatever that role looks like. Okay. There was discussion about also applying it to teacher tools. So in this case, any product would include software used to transmit student data and that is used for teaching and learning. So that conceivably could bring in some teaching tools that they use for grading and other purposes that a teacher could do.
so this means then that anything a teacher is using, even for their own purposes,
If it's for teaching and learning, right?
in the classroom.
In a school. Yes.
Okay.
Not at home, in a school.
Yeah.
And presumably that tool could also be used in school. And that may be a blurry line here. Okay. That's the first change. Number 2, no change to filing. So number 3, the change school being highlighted is that previously said school or school district. What I've done to kind of clean up the bill is school includes school district. So where you see the term school, that also includes school district. We can take testimonies that are appropriate or not, but I think it makes the bill easier to read. And so you see school now including the definition of school district. That's the highlight portion on line 13. Line 14 is a new definition. It is the major, section 11 definition of school district. Cross-reference there because we're not in Title 16. So because we're not in Title 16, I don't want to just assume that people know what that term means. If you use school district in Title 16, it has to be defined that way. It has to be used that way. But I'm using the cross-reference there to ensure that it's used that way. Okay. No change to the mandatory data reporting, subsection B. At least that intro subsection. Then on to page 3 of the amendment. No change to number 1. These are the registration requirements of an ed tech provider that is doing business in the state must register with the state as such. They must provide their name, email. That didn't change. Number 2, a link to their most recent version of their privacy policy. And the highlight is in school, because that phrase was added in this amendment. So previously it stopped at each product in use. So this narrows it a little bit, and maybe matches the definition of an ed tech provider, is they must provide a product in the school, right? So you have some language matching up there. 3 added the word paid. So previously the language was, sure, let's write here 3, operating pursuant to a contract. So now it's to a paid contract. So conceivably, I guess you could have a contract where there's no payment between the school and the ed tech provider. This would limit it to just contracts where the ed tech provider is paid to offer that service in school. No change to 4 or 5 or 6. So they still must describe the product, which products are known to be in use in any school, and then they must attest that their product meets existing privacy laws in this state and in the federal government. Any questions about those registration?
No. I have. What page are you on?
I'm on page 3 of the draft.
Yeah, I want to make sure I'm not ahead of you. Are you down to enforcement?
Not yet. Not yet. It's coming up. Yeah. Okay, so subsection C is new. Previously there was no enforcement to the registration. So in other words, a business, if they didn't register, there would be no harm to them, if damages. They wouldn't have to pay anything, or they would just not register. So you have enforcement language added that puts this requirement to register under the Vermont Consumer Protection Act, which is where a lot of privacy laws eventually get gathered into.
So this section entirely new?
Yes.
Okay.
It's language that appears elsewhere in Title IX, but this is new to this bill. Yes.
The source. Who provided the language?
So that can discuss language that's used in bills, but I can run it separately.
Thank you.
Sure. So section 2, so you have 1, that a person that violates provision is an unfair and deceptive act in commerce. That is the Vermont Consumer Protection Act. Number 2, the AG has the same authority to adopt rules, so now they get rulemaking, implement the provisions of the subchapter, and to conduct civil investigations, enter into assurances of discontinuance, and subdivision 3 coming up, bring a civil action pursuant to the Consumer Protection Act. It's a little bit,
If I could, so page 3, line 19, section 2453.
Yeah.
You may have just said it, but what is 2453?
so it's the Vermont's critical Consumer Protection Act provision that says if you create something that is a deceptive act in commerce, it violates the Consumer Protection Act, to reference that specific section creating that.
Consumer protection.
So continuing to page 4. And I do want to say a little bit here, we're talking about registration. It's not common for a enforcement to be tied to registration. If a company doesn't register, AG enforcing some type of consumer protection is not typical. Doesn't mean you can't do it, but it's a little bit of an outlier to have that type of enforcement instead of a penalty, right? That's typically you'd have a penalty of a certain amount of money for not registering that the AG would enforce.
Now, the initiate a civil action against the person pursuant to the subject. Clarify that a little more.
So yeah, we're on 3A on page 4, right?
Mm-hmm.
Okay.
Line 12.
So the Consumer Protection Act gives the AG the authority to bring civil action,
All right.
amongst other things, to adopt rules, civil actions, investigations, right? It gives them that kind of blanket enforcement mechanism. What 3A is doing is kind of narrowing that to say before you bring a civil action, before you bring it to court, you write them a letter saying that we believe you violated this, you haven't registered in this case. Please register in 60 days. You have a cure period of 60 days. If they register within the 60 days, there's no violation. So subdivision B, if they do not cure, which in this case is a registration, then the AG could bring enforcement and could sue the business.
You know what, I hate to do this, but I think we need Senator Rushing in this section. It doesn't make sense to go forward without him being here. Let's see, I know he just said he wanted you to go grab the signature.
Jump in.
Well,
Yeah, there's more. There's things unrelated to that.
yeah, let's see what, okay. Yeah, so let's go to section three, right?
Section 2,
So,
bottom of page 4.
oh, yes.
New language, new idea. This did not come over from the House. So this would be a 5-year prohibition on chatbot in schools. And we define chatbot later in the section. So subject to subsection B, which is important, no school shall allow students to use a chatbot for teaching and learning purposes until June 30th, 2031. So roughly 5 years. There's an exception to that. A school principal or head of school shall have the sole authority to grant an exception to the prohibition, provided that the chatbot is strictly used for educational purposes. The principal or head of school shall track any and all exceptions made pursuant to the subsection and provide a list of exceptions to the Agency of Education upon request. The list shall include the name of the provider of the chatbot, along with an explanation of the educational purposes of the chatbot. So you're giving that principal, head of school, the sole authority, as long as it's strictly educational use, which is somewhat subjective. One may disagree with another on what educational purposes. However, they all must include this list that includes the name of the chatbot and the reason, explanation for the exception.
So I'll go on the record as saying I would oppose this section. I think this is the purpose of the working group, is to determine which tools are or not appropriate for the for inclusion in schools for academic programs. They may very well deduce that chatbots have absolutely no place, or they have some kind of limitation. But putting it into we have a bad habit of requesting a study, but putting solutions into legislation before the study is ever delivered. I'm a no right off.
Same. I'll still go over the definitions, so everyone can see them. So a chatbot is any artificial intelligence, algorithmic, or automated system that generates information via text, audio, image, or video in a manner that simulates interpersonal interactions or conversation. This is a new area, not just of law, but in tech. So states are still kind of grappling with how to define a chatbot. This definition appears to be one that is proposed in various ways. So having to entertain a change to that definition is certainly a proposal that you will talk about. Definition of school is a cross-reference to Title 16, which includes independent schools. And then the notice is the AOE must provide notice of these provisions to all schools, and if necessary, provide support to a school in implementing these provisions on or before August 1, 2026.
Guess we should go back now. Waited for Senator Sheen.
Sorry, yeah.
To what I told I hope for why.
For sandwich.
Well, thank you. So go back to page 3, right?
And yeah, and I'll maybe give the senator a little background. So we're talking about the registration of EdTech. Language being adjusted a little bit as far as who must register, the definition changing. I think the purpose that you may be able to provide some testimony on is or not testimony, comments off this enforcement. So what this amendment would do is basically allow the age, if a business does not register, who meets the definition of a tech provider, the AG would be able to enforce that either through a lawsuit or some type of warning, like we think you are operating in Vermont, however, you have not registered as an tech provider. It falls under the Vermont Consumer Protection Act, which gives the AG authority to conduct civil investigations, bring civil action, and so forth. The important language is on page 4, 3A and 3B, that there's a cure period of 60 days where the AG would have to write notice to the ed tech provider, giving them 60 days to basically register to avoid a lawsuit. And if they didn't do that, it'd be that the AG could then prove to enforcement and the corporate.
Is this similar to what was in page 816, or is that private right of action as opposed to the civil right of action?
What's the bill number?
816.
816. I don't have that bill, but this would be totally civil. There's no criminal enforcement here.
816 was a private right of action. This, I think, for an individual sue rather than the AG. I believe, and some of the language is looking very similar.
Okay.
I'm just wondering if this is copied and pasted from 816 for whatever reason.
So this, what you're seeing, the not 3 and 3B, that's unique. But 1 and 2 are almost verbatim what you find in the Consumer Protection Act in Title IX, which I mentioned before you came in. It's a little strange to have this connected to registration. Typically, it's you do something that harms the consumer directly. You sell a car that is a lemon. You sell a dishwasher that explodes, right? These are consumer harms that consumers have a right to the courtroom. So the registration piece is unique, but it's the same language that allows AG enforcement and a consumer the path.
AG enforcement just against failing to register.
Right.
And it's only the AG that can do it.
So no, this would also involve consumers, and we would need to discuss if you want to limit the consumer right to action. This just limits the AG right to action. The consumer, they would have to show damages. That's what's the damage to a consumer or business not registering? There is some damage, but it doesn't block the consumer right. So that's something to note.
Having this in here doesn't block the community.
Correct.
Oh, they basically said anybody can sue anybody for anything, correct?
Well, so you have to show damages in this section, and my point is that what's the consumer going to show? So what's their harm for a company not registered? That's going to be hard to do. But the AG could say, because the Consumer Protection Act, we believe there's a violation by not registering, and we want you to register.
And we heard testimony from that's doctor that is showing that actually use of electronic devices have made us dumber. So could there be a using this be a class action suit? No, I'm not gonna.
It's a pure, and I can say that confidently, I normally can't, but because it's just strictly registration, like what's the damage? Okay, and that's why I said you maybe consider a penalty. That to me makes more sense here than the Consumer Protection Act. Is you say you don't register, it's $10,000, whatever the penalty is, right? That to me makes more sense than a AG enforcement of the Consumer Protection Act. But up to you all to determine how you want to, if you want to enforce it at all, right? The House brought you a bill with no authority.
What did you say makes more sense?
A penalty, like again, as far as legally, the AG, I'd want to hear from the AG, right? What they prefer. But to me, the point is to get companies registered that are doing business here. The Secretary of State, if you don't register, there could be a violation of your in Vermont, but you're not registered as a foreign jurisdiction or you're not labeled as a corporation. There could be a separate violation there. Like here, we are in the world of ed tech, and you're saying that a business that is operating in Vermont that has a product that is being used in school is not registered as an ed tech provider. So what is that violation look like? What should that be?
So when businesses register or have to renew their registration, if they lapse on it, and their license is suspended and, you know, with whatever license or registration they have, they have to pay a reinstatement fee. Yeah, and so I don't know why there would be a AG action on something that seems similar. Because what I'm understanding, the question is these businesses that are operating in Vermont with their ed tech products, they have to register, right? And in order to use your products in Vermont, you have to be registered, right?
In order to use,
In order for their products to be sold, you have to be sold or utilized by in whatever district,
like in distillers in general.
generally speaking.
I mean, if you do business in Vermont, let's say you're a Delaware corporation, right? You should theoretically have a either DBA or be registered as a foreign business in Vermont. How many do it? I don't know.
Yeah.
But yeah, you're supposed to, if you have this in Vermont, you're supposed to register as a entity with an agent that you can serve papers to if that company violates the law.
So then I mean, I guess why is there a bifurcation between AI and tech products versus all other businesses? I mean, I'm all for regulating AI and technology in schools, but
Probably not a question for me.
Right. So, I mean, and I think that there it is an extremely fair question because I don't know that a registry gets us a significant benefit. I've told the house, you know, I'm not sold on the registry. Their goal with the registry is to have a better sense of what products are being used in our schools. And that for consumers to have agency, there has to be, and I'd actually love if we want to pull up the California data broker registries. I basically tried to say to everyone, people should just look at this registry to get any and all useful information about the companies that operate in the country, what kind of information they collect and who they sell it to or transmit it to, which the California one is beautifully done and shows you the 566 data brokers that have registered with the state. What California can then do is delete your data from those, which I think is also a challenge. And we're dealing with that in economic development. But the goal of the house with the registry is so that they know the universe of products being used at the school. If a parent goes to a district and says, why was my kid on this app? And the school says, I don't know, or we have a contract with them, or, you know, we have, you know, then the parent has more agency to know, did the school authorize the use of this product? How else did they get access to it? Is it considered an educational tool that's efficacious for learning, etc.? They eventually want the registry to point to better policy in the future. That's the best I can say about it. I do struggle with the registry, but if you pull up the California data broker registry, I think you'll see that other states are also starting to approach really useful consumer databases that we are not near yet with our Secretary of State. I think the bigger question is, how do we get it? There should be no products in schools that have advertising. There should be, you know, relatively limited use of chatbots. Well, those are a new social interaction that we're having in society. You know, I think we added other pieces of the bill, frankly, that I think matter more. The House wants this registry, and I just tried to fix some of the language in the registry so that it would actually get us the information we might want for future policy.
So, yes.
I'd like to go back to the plain old opt-out.
parents that wanna opt out, your kids having access to any.
So,
So why can't we put that in?
well, I mean, I don't know if that gets into education policy. I do believe like for most technology in schools, a parent can opt out.
Well, I've seen.
But that, I mean, that's
They
kind
took
of
it out of
outside
the
of the
bill.
scope of this bill. We have a working group in here to spend the next 6 months coming back with policies that say, what is age appropriate? At a certain age, the most appropriate thing is no screens at all. At a certain age, you know, they're teaching kids how to type and use like math programs or whatever. We're gonna try and get into all those details. If you want to put an opt out for kids to use any screens at all in school, I'd be fine with that. I do think that's a bigger education policy that's probably addressed in what parents can ask for now.
So if we don't tell them that they can do it, then,
So why don't we, because we're almost out of time, so why don't we finish the thought, you're done section one, we've done section two, now before we go on, three, something like that.
Just finish two. For the chat line. Okay. Okay, section 3. So the House passed version had a AOE study that was going to look at the certification of EdTech products, kind of using the registry as part of its work. This has been revamped. It is now a legislative working group, so not AOE, just legislators that would be tasked with studying the use of EdTech and providing a recommendation through draft legislation on how it should certify products. So membership, starting now on page 6, 3 members of the House by the Speaker, not all from the same party, and 3 members of the Senate, not all from the same party, appointed by the committees. So 6 members. Powers and duties, the working group in consultation with AOE, the Vermont Superintendents Association, and the Vermont Independent Schools Association shall study and make recommendations regarding the certification process for the use of EdTech products in Vermont schools. So some of this is in the House language, but I also had to rework it because it's a different look at how EdTech would be regulated, and this would be draft legislation. Now, we're not talking about a study with a report. We're talking about a bill that somebody in my office, like me, would draft. So the working group 1 shall, in consultation with superintendents, create a list of educational tech products in use across schools in the state. Interview stakeholders, including teachers and children's privacy advocates, to determine the benefits and harms of using EdTech products in the classroom. 3, determine what criteria to use when evaluating products for certification. 4, determine which state entities will be charged with the certification process and what extent. 5, recommend whether any third-party services should be utilized to assist in certification. For the assistance, it would be list of counsel and JFO in case any financial issues can come up in that work. And then subsection E, the proposed legislation. On or before December 30th of this year, the working group should submit its findings and recommendations in the form of proposed legislation to House Commerce, House Ed, Senate Economic Development, and Senate Education. Then you have meetings language, pretty standard. First meeting on for August 15th. There will be co-chairs, one from the House, one from the Senate. They shall cease to exist on January 15th of 2027. And then the standard per diem language would be limited to 6 meetings coming out of the General Assembly's budget. One more section is the bill takes effect July 1, 2026, except for the enforcement mechanism. So that enforcement mechanism, back to the registration piece, there'd be a 2-year delay on that. So there wouldn't be any enforcement to give time for EdTech products to providers to register for the state. Give them 2 years to learn that Vermont now requires this registration.
Yes.
Questions, working group, was the composition of legislators only, part of the House bill as it came in?
So the House bill had the AOE during the study on their own, and this is a brand new
Yeah, so I'll offer to the committee that I'm not a big fan of, I don't think we have 6 legislators who are IT subject matter experts to handle a topic like this.
There are other reasons that you just have legislators, that given that the budget is passed and there's no other agency that has said they will staff it. So the only way to have council staff it is to have it only be composed of legislators and then just bring in the expertise you need.
Okay, does AOE decline participation or leading the study group?
I don't think I talked to them outside of the VitalLearn and AOE coming in together and saying, and some other people saying we'd rather you just use VitalLearn. I think people have seen my emails. I went down a rabbit hole with VitalLearn and I am now pretty unconvinced that it's a good gatekeeper for what is good learning tools for our kids. I'm not denigrating IT experts. My stepdad is an IT expert, but it's generally a consortium of IT faculty and staff from our schools, bulk purchasing products. I have looked at a couple of those products that I very much question, and I think at least one of them would not make it through the AI chatbot pause, because it is promoting a girl talking to a chatbot as her main friend. And I think they should take it off the website, now. But I would say that I am pretty convinced that AOE leaning on VitalLearn is not a good way to go, and that's what they recommended.
Okay, that's the essence of why we want to work to analyze the issue.
Mm-hmm.
I'm always hesitant to include predetermined conclusions before we even ask for the study group, let alone get the results of the study group. I'm also not a big fan of legislators being the sole members of any study group. It becomes very potentially political and there's not a depth of subject matter expertise on the topic. I'll leave it at that.
I just asked a clarifying question, so track. What is the predetermined conclusion?
Well, one is a 5-year prohibition on chatbots. The other is the comments that Senator Insiders made about whatever software application, which I'm not familiar with, but I don't know if it's good or bad, and I'm not going to go be in committee and make, determinations on what something should or shouldn't be included for the study group. You have the opportunity to do this. Just very hesitant.
So we'd have to add Angie in here. Agency might want to testify. Not sure who else. Thank you for this discussion, but thank you. You can have that. So what's the committee's sense about this? Yes.
Not to be a contrarian, conflict left you, but I'm all for the 5-year prohibition on chatbots in schools. It's not like they've been around for 20 years or are an integral part of education. And so, it's not as if there are some profound benefits groundbreaking benefits that we've heard about regarding AI that absolutely need to be in schools. I don't see it, but there are concerns about the harms of AI and chatbots. And so putting the pause on something like the chatbots and letting the committee or the study group do its study, I think makes more sense. And then if somehow they find out that chatbots are absolutely great for kids, then we move on.
Not great for kids, but maybe appropriate at certain ages, certain settings, it's a tool. What it is. It's like there was a time when everyone globally was afraid of electricity. They didn't want electricity in their homes. This is, there's direct parallel here, but AI is a tool. Period. Chatbots are a tool, and how we use them is an appropriate lesson for students as well as
I think it has a impact on, as when you're young and you're developing your brain, there is a impact on the cognitive ability or the cognitive development of kids if they're heavily dependent on chatbots rather than using their own brain to resolve the problem. That's my concern.
I will also say, just to point back to the language of the bill, it's asking schools to make a very conscious decision if they're going to introduce a chatbot, that the building leader, the principal, should essentially know that a chatbot is being used. No school, I don't think, wants the liability of kids that were supposed to be using some educational chatbot having a big major health challenge or mental health break because their relationship was with the chatbot.
No argument. But we're talking about section 2, which is a prohibition.
With an
That's-
exception.
Okay.
It's saying make a conscious exception.
So we're just remind us here, as the bill came over from the House, it had really two things, right?
Right.
First one was the
Registration,
second one,
the AOE study and certification.
okay. This one has now kind of three things going on.
Right.
One is the same, relatively speaking, the same registry. Well, actually, maybe it has four things going on. The other's now the aging enforcement mechanism. Third one is the prohibition on chatbots. Fourth one is let's say we're supposed to that. So if we've got those two buckets versus the four, what do we want? Where are we headed here? Where do we want to be? More testimony and
I got the same concern that Senator Weeks did about having all legislators. I mean, how are they qualified? I'm not. And even if I was, I haven't got the time to do it. So we're gonna end up with legislators that have the time that maybe I might not have on that study. So I think we needed somebody from the outside.
but yeah, this gets really, this is a philosophical.
Yeah.
Because I have in the past, here we are setting education policy.
Right.
We're doing it right now. That's what legislators do every day on the one hand. And I've actually tended to be one who believes legislators should be listening to some of the other people should be.
Should be in them, shouldn't be 100%.
No, I've always believed in 100%. That's just, I've been consistent about that. So it has nothing to do with this situation, because just like we do here, we are it. We don't have people from other sitting here with us. So they're part of
Who's
the-
gonna guide?
Yeah, they are, but they're witnesses. You can have the same thing. So that's just, I didn't even want to get into it. But
Sure.
That's
And
just my.
I'm not even
my-
wedded, I'm not wedded to this. I think you asked the right question. Who would staff it? With AOE, I don't know if they're here, but AOE was not asking for more things to do. They were actively proposing more things to do. It could be in ADS, but we'd have to get them in to see. If you only have legislators, you can have council staff it, which means they're drafting what looks like our legislative language. Once you put a non-legislator on that, it can no longer be staffed by leg council. Yeah.
Who do we need for witnesses? We don't have a lot of time here, so.
Well, what's the most important part of this bill? Starting the registry and that, which I think is what we were looking at to do. This other stuff is add-ons, the chat box, the study groups. Study groups, I believe would be a good idea, but some of this other stuff could wait. Like the chat box could wait for the study group to come back this and say, okay, we've done a study, definitely need to put a prohibition.
Well,
Or you've done a study
yeah,
and there needs to be a condition.
I wrote the other parts of the bill with the House members who were involved because I don't think the registry is that valuable. I'm just gonna they know how I feel. Like I honestly don't know what information we're gonna get in 2 years from who decides they're ed tech and needs to sign up for the registry. In the next 2 years, I think we're gonna see a huge increase in the use of generative relationship technologies or whatever they're called. And I have concerns about what is being put in front of our kids right now. And I think right now it would be good. I'm pointing at the screen because I would really ask us, if you didn't click on the link I sent, to look at Inanimate Alice. Is a program that is bulk purchased for our kids, where you never see the girl's face. She is looking down at her phone and she is talking to like Brian or something, her AI chatbot friend, and cleaning her kitchen in the elementary school program and traveling the world with her AI chatbot friend in the high school program.
But whose fault is that?
It's on the IT system that AOE said just use the programs here.
Okay, so Senator Shane.
Yeah, I was just gonna say, I think the prohibition is my priority in all of this. I don't think these corporations are going to care about or register, and more than open to going down to 2 years. And because I mean, this technology evolves extremely quick. And so maybe 2 years, but there has to be a check back before prohibition is lifted.
So I guess I'm sitting here thinking, we somebody from the AG's office, maybe a couple of superintendents to weigh in on that. If they got the stuff. Getting the AG and a couple of superintendents or a couple of principals, whatever, just to get some, somebody.
And it has to be that they're using this in their school. That you have
Or
a
not.
Superintendent.
Either way.
Or they may
So I want
Yeah.
each.
Yeah, let them go ahead and help.
I'm kind of looking to our school board folks, because I think school boards are going to start getting questions about what is happening. We heard, stories of kids getting onto other parts of the internet on their school issued device. I'm sure you all are talking about this. So if you have superintendents or other people that want to weigh in, I mean, I just feel like parents are asking school boards what is happening.
Think about a couple of superstars.
Yes.
Okay. All right. Good for today, because we have to move on. So, and so Daphne will, Sue will try to we'll get you a couple of superintendents, and we'll get some of the AG's office in next week, and we will get into this discussion. Yes. So next is what we're on the miscellaneous bill. I'm gonna get the copy, but start with that thing right here.
Good afternoon, Sophie Zadatni for the Office of Legislative Counsel. And I was contacted about this last night, so I just wanted to check on what would be helpful to all of you, because I did come in last session. I updated the it's like you're getting copies, I bought copies too. So I can just go through that sort of swiftly. My understanding is it's really dealing with last best offer and the way the final resolution of disputes goes. So I could focus on that.
Yes,
if you would
the
prefer.
proposal in front of us, it's a single sentence that would shift from last best offer to the arbitrator being able to pick and choose from the two sides. So that's the question in front of the committee, which took us back to
Okay.
you.
All right. So do you want me to run through the PowerPoint? I mean, I can do that super fast
Yes.
and just skim through it, and then
That's
okay. I'll just get through it quickly. So this is really just providing an overview on the state law regarding Commission on Public School Employee Health Benefits. Has a history of how this came to be, the creation of the committee, and again, just to be clear, VHI continues to develop the plans, and then the commission, this is the composition of the commission. 10 members, commissioners serve in a partisan capacity, so you have 5 representing school employees, 5 representing school employers. And then the chairman, who can be removed. This is the duty. So this is what the commission itself decides. So again, VHI still develops the plans, but these are the items that the commission itself looks at. And I'm on slide 2, 3, 4, 5, 6. So they determine the percentage of the premium paid by the employer and employee, the out-of-pocket expenses, whether to establish a health reimbursement account, a health savings account, or both, who bears the first dollar responsibility for out-of-pocket expenses, and then a grievance procedure. Contracts, if they're not less than 2 years in duration, the dates on here reflect when decisions, what happens in the process right now, because it's a lengthy bargaining process. The current contract expires at the end of 2028, but as you can see on this, the process for the next round of negotiation starts this coming October. So again, it's a lengthy time because of school budgeting, etc. If the parties are unable to resolve the issues in front of them, then there's a dispute resolution process, and this sets forth what the fact-finding process is. So a fact finder tries to mediate the outstanding matters, prepares a report. The report is not binding, and then if the parties are unable to reach agreement, within 30 days after receipt of the fact finder's report, then they go to arbitration. My understanding is that's where the focus is here. And so the mechanism is the commissioners mutually agree on a single arbitrator, or if they're not able to agree on a single arbitrator, then there's a panel of arbitrators, and each side picks one arbitrator, and then the third arbitrator is appointed by the American Arbitration Association. And the parties submit their last best offer to whichever mechanism they go down, the Labor Relations Board, the arbitrator, or the panel, on all outstanding issues. And then under current law, the Labor Relations Board, the arbitrator, or the panel selects one of the last best offers in its entirety without amendment. And then they weigh a number of statutory factors. So those are the factors in current law that the decision maker, the ultimate decision maker here, considers. So the interests and welfare of the public, financial ability of the ed funds in school districts to pay the costs, comparisons of healthcare benefits for similarly situated public and private sector employees in Vermont, cost of living, and prior and existing healthcare benefits and coverage with school employees, and then they issue a final and binding written decision. There's no ratification required by either party. This is the decision. And then this is just emphasizing that under the Labor Relations the Act for Teachers and Administrators, there is a right to strike. Under this statutory provision around the commission, there is no right to strike. And I share that because I think that has some bearing on how these issues are resolved. And as some of you may know, we do have 7 labor relations statutes in Vermont. So I just pulled together what that looks like. So again, Commission on Public School Employee Health Benefits, when you get to that point where there's an impasse and you've gone through all the other dispute resolution mechanisms, when you get to the end, the decision maker selects one of the last best offers submitted by the parties without amendment, right? So that's the current law on how this works right now for the Public School Employee Health Benefits Commission. Under the Labor Relations for Teachers and Administrators, the parties can mutually agree on whether to have binding arbitration confined to the last best offer of the parties, so in its entirety, or they can choose to have an issue by issue basis of the last best offers of the party. So that's the parties themselves decide that when they get to sort of final dispute. They've gone through all the other mechanisms, and this is the end of the day. And there is a right to strike under the Labor Relations for Teachers and Administrators. Under the State Employee Labor Relations Act and the Judiciary Employee Labor Relations Act, again, it's last best offers submitted by the parties without amendment, or if the offers of both parties are considered unreasonable and unlikely to result in a long-lasting negative impact on the parties' relationship, then the decision maker, again, could be the Vermont Labor Relations Board or an arbitrator. They could select the fact finder's recommendation. So they ultimately would have 3 choices: last best offer of either party or the fact finder's recommendation. under the State Labor Relations Act, which is almost never used, and the Municipal Employee Relations Act, there is no last best offer provision, and there is a right to strike under both of those. And then we have these two quirky labor relations statutes that involve negotiations with the state really over reimbursement. So they're sort of odd ducks. But between the language and those two statutes is the board would select the last best offers of the parties in their entirety, but they also would consider the selections cost. And again, there's no right to strike under that. So there is a array of approaches under Vermont's labor relations laws. So I just thought that might be helpful context for you to have.
Have you seen the language that was proposed yesterday?
Not formally. My understanding was it was to provide that the arbitrator could make an issue by issue determination.
So basically it says an update to 16 BSA 2105 to the Vermont Labor Arbitrator or arbitrator shall select the last best offer of each party on the inter basis with or without amendment. So by the way, I can just close this to you. So naturally that's simple.
So the purpose of a last best offer is the goal is when parties confront the possibility that the decision maker is going to pick one or the other, the incentive there is to make your last best offer as appealing as possible, as reasonable as possible,
Yep.
as moderate as possible. To sort of, so it's a mechanism to push the parties as close together as can be. If it's an issue by issue matter, then it doesn't have quite that same impact. So it's just a different approach. But
Okay.
that's the purpose behind the last best.
So I know, I understand. I actually meant if we were to want to do this, and Trip did just forward to you, is that language sufficient to achieve what we might be looking to achieve?
Doing it, so it would be, I don't know how many times, but it would be the last best offer on the issue by issue. So each party would have a last best offer on a particular topic.
The whole thing, but I sent you.
Oh, sorry. I don't have my email up, so.
This is
Okay.
what was sent by Sarah.
Yes, yeah.
Although, yeah, I mean, I don't know where.
I'm just thinking technically, is that was my question.
Gotcha, okay. Shall set the last vote for each party on an issue by issue basis with or without amendment. Right, so, yeah, I think that would, that could be it. I mean, essentially, as I understand it, what that language would do is, topic A, each party puts forth its last best offer on topic A, and the decision maker can choose between either of those or could change it, right? With or without amendment, they could change it. So again, you're really moving away from the last best offer concept. This is more of pick and mix.
Yeah.
Right.
That's it.
I was about to ask, and then you said it. It's not really a last best offer if it can be changed.
Right. If it was without amendment, if it was issue by issue without amendment, you would still have some incentive there for each party on topic A to put forth what they can live with, so to speak. But if it can be amended, everything, probably the incentive would be for each party to, sort of go to the outer edges and then see where the decision maker lands up.
Seems like it's never had. I mean, if you put it with or without amendment, it starts to have a lot more uncertainty and ambiguity in the process. Just general comment.
Yeah, it's different to the last best offer concept and the sort of rationale behind it at that point.
Yeah, the question really does come down to if you want the last best offer or one the parties to put forward their proposals and they're against it, they can choose within those lines. That's the question for us. So actually we have more witnesses, so we can follow up on these questions.
And I was just gonna say, under the Teachers Labor Relations Act, it is last best offer. They can choose to have last best offer, just pick the, the entire package, or last best offer by issue. But I don't think that would be without amendment. So, okay. Right.
Thank you. We'll be in touch. Well, you're welcome to stay. Listen, whatever you have. So, yeah.
Nice job, Sophie, putting this together in such short.
Good afternoon. Thank you very much for allowing me to come in on this issue. I'm Sue Siglowski, Executive Director for the Vermont School Boards Association. And as you've been speaking about, we are asking the committee to consider adding a new section to the miscellaneous education bill, which would revise one sentence in 16 VSA Chapter 61. That chapter covers the Commission on Public School Employee Health Benefits, as Legislative Council just described. This commission was originally created as an effort to contain the pressure of rising healthcare benefit costs as they impact the education fund. There have been two rounds of bargaining so far, and the results of these two rounds of bargaining have not reached that goal, in part based on the current structure of the statute. So specifically, we are asking for the change that I have noted in my written testimony, which you have, changing the sentence that the sentence says that the VLRB arbitrator or arbitrators shall select one of the last best offers without amendment submitted by the parties prior to the VLRB or arbitration hearing in its entirety without amendment. And we are asking for that to be changed to the VLRB arbitrator or arbitrators shall select between the last best offer of each party on an issue by issue basis with or without amendment. I wanted to note that the arbitration panel decision following the second round of negotiations contained the following statement, and I'm quoting: "The arbitration panel has considered the statutory factors and reviewed the evidence and testimony in making its final decision. As stated at the outset, this panel's statutory authority is to award either the employer's LBO proposal package or the employee's LBO proposal package. It cannot accept portions of the employer's or employee's packages. Perhaps this arbitration panel would have reached slightly different conclusions than of the finder of fact, Mr. Cochran, as there are no clearly right or wrong answers to these weighty and complicated issues." So the bottom line is, winner takes all arbitration limits the arbitration panel. This was a panel of very experienced arbitrators, making this statement that they would have or possibly could have come to a slightly different conclusion if the law was different, and that's why we are asking for this change.
Questions?
Can I ask a question? So, I mean, there's a reason that a last best offer dynamic becomes important, right? You have negotiated, you have mediated, you've come to impasse, and you're both trying to put something on the table that the Vermont Labor Relations Board will accept as the chosen proposal. My understanding is the one side of the negotiating table with VHI, I don't know if I'm saying this correctly, has not been successful 3 times in a row. Two times. So do you have a sense, can you share an example of where you think they would have chosen like one of your proposals and another of the other side's proposals?
I can tell you that the last time this took place, the two sides' last best offers were extremely close.
Okay. and they just happen to choose one.
Yes.
Kind of the process working.
What happens, you must have also had ones that were extreme flows. What happens?
I will let Mark Koenig speak to that. He is actually one of the commissioners. He now works for the Vermont School Boards Association, but he was one of the commissioners in the last round of bargaining.
So I guess for the record, Mark Koenig, the SBA, but for this purpose, I was on the commission during the last round and then became the chair. And then once I took this job, I stepped off. So during the process, we have a bunch of issues that are on the table. We negotiate them, and that gets us to mediation with fewer issues. We negotiate those, we get to fewer issues, so we get to a point where we just can't settle on the last few pieces. The last round of negotiations essentially was over $100, and it was decided on for the employees. So it was a matter of how much the HRA would be handled. And the employers were asking for, I'm making up numbers here, but the HRA is $5,000. First 4,000 is the employers, the next 1,000 is employees, and then insurance takes off. We wanted to move that to 3,900, 1,100, and they wanted to stay at the teachers union wanted to stay at the 4,000, 1,000, and the arbitrator went with that. So
So in that case, the last best offer construct actually did drive the party to bring those together.
In that case, it did, yes. And I think it illustrates that with that process, there's not a chance for the arbitration panel to be flexible and make a flexible decision. And that's what they pointed out in the quote that I read to you.
that was not the only issue at arbitration. It wasn't just one.
So, okay, that's this right, came down to that, okay, yes,
I think it would be fair to characterize any arbitration process as trying to bring the parties closer and closer together. That's the whole function. The point is, at the end, when you find out where the gap is, how you resolve that gap is the whole question. I think everybody respects the arbitration process. Except for the, thank God.
And in the past, the health benefits were bargained at the local level. And as legislative council described, that's a different process. And it's not a required last best offer in its entirety every single time.
so that's best offer ever used at that level?
I believe at that level, the parties can voluntarily agree to binding arbitration. And if they do, it's not a last best offer in its entirety.
Thank you, so I think Jeff, you're up. General counsel, okay, that's fine. Hello.
I am Rebecca McBroom, General Counsel with Superfund A. I have testified, I believe it was last session about the same issue, so I will repeat sort of what I went over that time. What I'd like to say about this process, I've been the attorney that's represented Vermont and EA in both. There's been 2 rounds of statewide healthcare negotiations. I've represented the union on both mediations for the arbitrator, so I've been very familiar with the process. But overall, in collective bargaining, and Sophie sort of talked about this, the process really is to drive the parties to settle amongst themselves. And that's why you go through so many steps of the process. You start out with collective bargaining, you get and pass any kind of mediator. That's like the parties need extra help to work them out amongst themselves. But a mediator doesn't oppose the agreement. And then fact finding is the same process. It's a little bit more formalized, but fact finders and the arbitrators are extremely experienced. They have to be mutually selected by both parties. The fact finder that we used in this last round of negotiation, John Cochran, has been doing this fact finding in Vermont and around New England for over 30 years. So he is extremely experienced. And we actually, I believe both rounds of negotiations, we have accepted the fact finder's report, right? We said, you are the expert, you come to some sort of middle ground here between the parties. We want to settle, and that's what we have proposed. We've never been successful with the SBA and the other sides of settling with the fact finder's report before we go to arbitration. The first round of arbitration, we had one arbitrator, and the second round, we had 3 arbitrators. Each party selected one arbitrator, and then those 2 arbitrators selected a chair. So this is a long process. I can tell you that the arbitration, the last round was 5 days. I believe we had somewhere upwards of 15 witnesses. They're hearing every detail of both sides. I feel that both parties get great ability to present their cases. And the idea of this labor relations, again, is that you want the parties to reach an agreement before you get into arbitration. And, you know, it's our position that if you move away from LBO, then the parties are not going into truly their last position. They're not really truly in good faith trying to reach an agreement. If you're going in thinking, well, if they pick and choose, maybe they'll select this and this. You're not really trying to go in saying this is the best that we can offer. And also say that healthcare is, you're well aware, is very complicated. And we're very technical with our last proposal that we bring. The premium is tied to what we're going to offer for the out-of-pocket expenses. We might offer something different if we're going to have an HRA versus HSA. So these are very intentional proposals that we're making based on what we think, you know, our members can afford and what makes sense with the system that we have in place for healthcare. So there is some concern as well, is that if there was this sort of mixing and matching that was done, I think that could have significant unintended consequences that weren't fully vetted by the parties going in. And again, negotiations are supposed to be in control of the 2 parties are supposed to control their negotiations process. This is ceding that control to a third party. I will just say the mixing matching that has been discussed under the teachers negotiations. That's if both parties choose to use the binding arbitration process, which, in my experience in my 12 years, has never been done in negotiations between any of our school districts and local unions. That's not at all the preferred process that our school boards and unions use. So
What is not the preferred process?
the binding arbitration process, parties do not mutually select that process. So this is quite different for us. The statewide healthcare process that ends in binding arbitration is not what we use for our normal negotiations ever.
So if you don't use it normally, it's being used here.
It's being used here because this is different. The statewide healthcare bargaining statute is separate from BARG.
I would also say,
And like the system, you're window that despite the fact you don't know use the system, in this instance, you do like the system.
I think that the last best offer, the way that this is what we have to navigate, and so we navigate it. I'm just saying that the comparison to the other statute and then mixing and matching of LBO's last best offers is not something we use typically in our negotiation at the local level.
we created a very high stakes process with VHI. You know, we thought it would save us money and time spent on negotiations if we did this at the state level. Unless we were gonna relitigate that, it's a really high stakes process to all of a sudden say, we're gonna introduce uncertainty at the very end and not go with more standard labor relations practice of binding arbitration, essentially.
I'm not taking a position here, but there's a difference between binding arbitration. Binding arbitration is not exclusive of either last best offer we were picking and choosing. So I think the fact that we're with binding arbitration is kind of sad. The question is within the notion of binding arbitration, which system we use. So I'm not, again,
I think this proposal de-incentivizes the parties from reaching agreement amongst themselves, and that's what you want. You want to incentivize the parties to reach agreement. There should be some risk going into that final arbitration that, you know, I really need to go in with my best and what I take, or else, you know, I'm gonna get something that's not the best outcome. But if you're not having that risk, then you're not incentivizing agreement between parties, which is what you want.
questions? Comments?
So hypothetical on this, where it was $100 part, and the arbitrator can, in this, can go, well, why don't we make it 50? And then each side agrees to that amendment. And it's done, but if we're doing it the way it currently is, it's either 100 or not 100.
Well, I think in the last best offer, they have to choose one or the other. So one
Right,
would say
and-
0 and one would say 100. The arbitrator can't choose
In
between
this,
two,
they
but
could-
no,
here they couldn't say.
no, they can't come up with a new number. They can just pick and choose between different provisions of the last best offer.
And like a contract. You can't
The
generally,
fact finder is the one that comes to a middle ground, I'd say 50. And so that's why the fact finder is that's a really useful tool to use fact finding recommendation.
Because the parties know they have to end up close to the fact.
They should,
Yeah.
yeah. Thank you.
Things. Soon as you want to add anything, if Paul, I'm still here. Those two?
No.
Okay. We actually don't have another witness until 3:30.
Wow.
So we have a break.
are we, okay, I mean, are we done with this issue? Are we?
Not done,
holding
no,
open?
no.
Oh, okay.
Yeah, we're discussion.
The next witness is at 3:30 for this?
No, we
Okay.
actually have no more witnesses for this lined up unless people have something they want to bring in. So, we have some time for discussion. We'll take a break. We'll take a break till 3:30. We have the agency coming in so hang on one second. We have the agency coming in at 3:30 on both the miscellaneous bills and the absenteeism bill.
Okay.
Because we've never been asked.